All right, welcome back. I've got a fun one for you. At least I hope it's a fun one because I haven't read it yet. I've only glanced at it very briefly. So even though I have a backlog of delete laws filings just piling up on me, um, I want to do this one instead because, as I've said many times, I think this case, Schofield versus Guillard, is way more interesting than reading about delete laws whining and his hypocrisy and just generally being awful. So, what have we got today? Well, as I mentioned, Schofield versus Guillard, TikTok psychic. If you recall, in my last video talking about this. So, well, let's just go to the docket. Good place to start. So, last time I briefly went over the judge had issued a ruling saying, "Hey, this is the schedule going forward. You've got to have a discovery plan in place by the end of June so we can have the discovery conference on July 6th." And I said in that video basically expect a responsive pleading this week from Professor Schofield and I guess kind of technically her lawyers, but that's all nonsense anyways, the claim against her lawyers. But if you recall, the on May 16th. So that is 21 days ago. So, hey, today was the deadline for a response. The psychic, TikTok psychic, Guillard, submitted her second answer because remember, her first answer, the judge struck that because she was in default at the time. So she answered and filed her counterclaims. And so Professor Schofield has to respond to those counterclaims. Imagine that. And if you recall, I told you in the last video, I don't expect an answer from Professor Schofield. I expect a 12b6 motion. What's the difference? So, if you recall, 12b6 is from the rules of civil procedure. It's a motion to dismiss for failure to state a claim upon which relief can be granted. So basically, with 12b motions, because there's 6 different 12b motions, there's, lack of jurisdiction, improper venue, uh, failure to state a claim, a couple others. Basically, they're use it or lose it. So you've got to bring them as your first responsive pleading. So generally, you're going to bring your 12b motions before an answer, and hopefully, you never have to answer because the judge just dismisses based on the 12b6 motion in this case, and then if the case is dismissed, you don't need to answer. Uh, Frankly, that's what I expect here, at least as to most of the claims. I think she brought 10 or 11 counterclaims, and they're all nonsense. I expect most of them, if not all of them, to be dismissed on this 12b6 motion. If they are not dismissed on the 12b6 motion, and procedurally, so we're going to have this. Uh, After that, we're going to have an opposition to the 12b6 from Guillard, possibly a reply brief from Professor Schofield. I doubt it'll be necessary, but it's, you know, possible, just possible. And then a ruling from the judge, and if he rules in Ashley Guillard's favor, then we'll get an answer from Professor Schofield. I'm not expecting that. So that's where we are. So let's take a look at the motion to dismiss and the memorandum in support of the motion to dismiss, which is docket number 22, which was filed today, June 6th. Still is, at least here in Utah, June 6th for another 23 minutes. So let's jump over. So this is the motion to dismiss, short and sweet. The memorandum will be longer. Defendant Ashley Guillard has filed 11 frivolous counterclaims alleging that plaintiff Rebecca Schofield had an inappropriate affair with a student, ordered the murder of 4 students, and conspired with her attorneys to sue Guillard for defamation, to evade suspicion, obstruct justice, and to avoid criminal investigation. In support of her claims, Guillard says her spiritual research into the murders at the University of Idaho intuitively led to the University of Idaho History Department. So she then spiritually inquired into each person listed on the History Department's website or webpage, and her insight for Rebecca Schofield revealed that she was in a relationship with Kaylee Gonsalves that broke up, and that she initiated the murders, planned the murders, and hired help to carry the plan out. In other words, Guillard made up the whole story. That pretty much sums it up. Made it up. Guillard's claims all fail because they rely on implausible and factually deficient allegations. The claims also fail to properly allege the pertinent legal elements. Even as a pro se litigant, Guillard should not be allowed to use this court as a platform to make frivolous allegations, to continue her shameless self-promotion at the expense of Professor Scofield's reputation and peace of mind and the victim's memories. The court should dismiss all Guillard's counterclaims under Federal Rule of Civil Procedure 12b6, or its inherent power, and exercise its inherent power to award Professor Schofield her attorney's fees. Dated June 6th, 2023, Stoll Reeves. Signed, Wendy J. Olson and Elijah Watkins and Corey Carone, attorneys for plaintiff. And hey, it was served via ECF. So let's jump to the memorandum in support. Like I said, the motion was short and sweet. It got to the point. This is the backup for it. So memorandum in support of plaintiff's motion to dismiss defendant's counterclaims. And really, all I've looked at is the table of contents and very briefly glanced at the final section. So this is all my first glance at this. So we've got the introduction, background, legal standard, and then the arguments. And just from looking at the table of contents, you'll recall, although lots of this is from way back in January or February, when I covered Guillard's first answer and counterclaims. So just looking ahead, the 4101, number 2, I'll get to that. So the arguments, the court should dismiss Guillard's counterclaims because they are implausible and legally deficient. Guillard's claims all fail because they rely on implausible factual allegations and impermissible group pleading that lacks specificity. Remember, you've got to plead sufficient specific facts to support your allegations. Otherwise, you haven't satisfied Rule 8 and the Twombly and Iqbal standards, and you're not going to survive a 12b6. So Guillard's defamation claims, counterclaims 1 and 2, fail because 28 USC section 4101 does not apply, and filing a lawsuit cannot give rise to a defamation claim. Now, you'll remember way back in January or February, I said, this is just a definition. This is not a cause of action, 28 USC 4101. It's merely a definition of what defamation is for the purposes of that specific statute. Just for that specific statute. And it's basically, it's for enforcing foreign defamation judgments through the U.S. federal courts. And so it says, this is what counts as a defamation judgment for the purposes of enforcing that foreign judgment in federal court. That's all it does. It's not a cause of action in and of itself, but as I said at the time, you're going to get pro se litigants thinking, hey, I'm in federal court, I need a federal statute. But even in federal court, defamation is a state level common law tort. So you've got to use the state level common law. That's it. You've got to use the state level common law. It's just in federal court under diversity jurisdiction. But she's under the misapprehension that you've got to use federal law. And then continuing, Guillard's 42 USC 1985 claims, counterclaims 3 and 8, fail for many reasons. And then Guillard's 42 USC 1986 claims 4 and 9, fail because she has not alleged actionable conduct under 42 USC section 1985. Guillard's 42 USC section 1983 claim, counterclaim 5, fails because she has not alleged any state action. Hey, didn't I say that? Guillard's malicious prosecution claims, counterclaims 6 and 7, fail because Professor Scofield's defamation action against Guillard has not been terminated in Guillard's favor. It can't be malicious prosecution if the lawsuit is ongoing. And finally, Guillard's intentional infliction of emotional distress claims, counterclaims 10 and 11, fail because filing a defamation action is not extreme or outrageous. Imagine that. And then finally, the court should exercise its inherent power to award Professor Schofield her attorney's fees. I have my doubts that it will, at least at this point, but I agree that it should. And then we've got a conclusion on page 12. So, introduction. Defendant Ashley Guillard has received a second chance to participate in this litigation after defaulting, and she has abused that opportunity by filing 11 frivolous counterclaims that serve only to delay this matter and increase plaintiff Rebecca Schofield's litigation expenses. In her answer and counterclaims, Guillard admits that the only basis for posting hundreds of videos online stating that Professor Schofield had an inappropriate affair and ordered the murder of 4 students is her spiritual research intuition, and insights. I would qualify those as BS, baloney, and nonsense. BS only because, hey, I like money and want to keep this monetized. To put a finer point on it, Guillard has relentlessly attacked Professor Scofield's reputation and made a spectacle of the tragic loss of 4 young lives, and she cannot even allege, let alone provide, any actual facts, lawful law, to back it up. Professor Schofield has filed a legitimate defamation action. Guillard's frivolous federal civil rights claims show that Guillard, even as a pro se litigant, should not be afforded any more leniency. I agree. Professor Schofield moves the court to dismiss Guillard's counterclaims and award Professor Schofield her attorney's fees. Background. In November 2022, 4 students at the University of Idaho were murdered at a home near the campus. As she has done since 2021 with other crimes, because remember, the Idaho murders aren't her first. She did the Shanquilla Robinson and Takeoff, the rapper, and various others. So as she has done since 2021 with other crimes, Guillard devised a scheme to leverage the tragedy in Moscow for her personal gain, use her spiritual acuity to post sensationalist content online to attract clicks and make money. The false story that she posted repeatedly is that plaintiff Rebecca Schofield, a professor at the University of Idaho, had a same-sex affair with one of the victims and then ordered the murders to cover up the affair. Guillard herself admits to posting over 100 TikTok videos related to her findings about Professor Schofield. Professor Schofield tried to resolve this matter without litigation to avoid drawing further attention to Guillard's specious statements at the expense of the victims' memories and their families' trauma, and Professor Schofield's own reputation and family's safety. That would be the cease and desist letter that she sent twice. She sent cease and desist letters on November 29th, 2022 and December 8th, 2022. When Guillard responded by making more false statements, Professor Schofield sued her for defamation. Instead of timely responding to Professor Schofield's claims, Guillard prolifically posted new videos and blog posts defaming Professor Schofield and accusing law enforcement of corruption for arresting and prosecuting Brian C. Kohberger for the crimes. To end the spectacle and to hold Guillard accountable for disregarding the court's deadlines, Professor Schofield requested a default judgment. The court exercised its discretion to give Guillard, a pro se litigant who promised this court she would be timely and responsive, a second chance. Guillard has used her second chance to file frivolous counterclaims that only serve to delay adjudication of Professor Schofield's claims and drive up her litigation costs, and as an attempt to drag Professor Schofield's counsel in as parties, which they are not. Footnote 1. Guillard purports to bring counterclaims against Professor Schofield's counsel. The counterclaims against Professor Schofield's counsel are not operative and not addressed here, as counsel is not an opposing party. Like I said, at the beginning, it's nonsense. I mean, it's just absolute nonsense. In her counterclaims, Guillard offers not even allegations of real evidence that Professor Schofield knew any of the victims had an inappropriate affair or ordered the murders. Guillard instead admits that she has used her spiritual acuity and investigative skills to get insight into the murders. In other words, she made it up. Guillard says her spiritual research intuitively led to the University of Idaho History Department. She then spiritually inquired into each person listed on the History Department's webpage, and her insight for Rebecca Schofield revealed that she was in a relationship with Kaylee Gonsalves that broke up, and that she initiated the murders, planned the murders, and hired help to carry the plan out. Based on these preposterous allegations and still no actual facts, Guillard seeks to sue Professor Schofield and her attorneys, primarily under civil rights statutes, for conspiring to silence Ashley Guillard to evade suspicion, obstruct justice, and to avoid criminal investigation. I like this motion. Well, I guess this is a memorandum in support of the motion, but I like this. Legal standard. A court may dismiss a counterclaim for failure to state a claim upon which relief can be granted. Federal Rule of Civil Procedure 12b6. Only a complaint that states a plausible claim for relief survives a motion to dismiss. Determining whether a complaint states a plausible claim for relief will be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense, citing Hong v. Recreational Equipment, Inc. from the District of Idaho in 2020. So imagine that. The court gets to use its common sense to say, you know what? Psychics don't reel, to use the vernacular of Sir Sick. They don't reel. Argument A. The court should dismiss Guillard's counterclaims because they are implausible and legally deficient. Guillard alleges that Professor Scofield's lawsuit against her is actionable defamation, obstruction under federal civil rights statutes, malicious prosecution, and intentional infliction of emotional distress. The claims all fail because they rely on implausible and factually deficient allegations that Professor Schofield had an inappropriate affair and ordered 4 murders, and impermissible group pleading that lacks the required specificity. Also fail to properly allege the pertinent legal elements. Yeah, like I said, regarding the defamation claim, she doesn't have the required elements because she's using 4101. She's using a federal defamation definition instead of using the elements of the common law tort. So the claims also fail to properly allege the pertinent legal elements. The court should thus dismiss all Guillard's counterclaims. Guillard's claims all fail because they rely on implausible factual allegations and impermissible group pleading that lacks specificity. Guillard's 11 counterclaims all rely on 2 premises. The first is that Professor Schofield ordered the murder of 4 students at the University of Idaho to cover up an affair she had with one of the victims. The second is that Professor Schofield and her counsel collectively conspired to deprive Ashley Guillard of her rights by suing her for defamation. Both premises are improperly pled, and thus Guillard's counterclaims should be dismissed. Guillard's allegations about the murders fail because they are implausible and lack any basis in actual facts. Federal Rule of Civil Procedure 8A2 requires only a short and plain statement of the claim showing that the pleader is entitled to relief. We've covered Federal Rule of Civil Procedure 8 many times. Even under Rule 8A2's lenient pleading standard, however, Guillard still must state a plausible claim for relief, and the court still must draw on its judicial experience and common sense, once again citing Hong, to determine whether her claims are plausible. Drawing on that common sense, a court may dismiss a claim as factually frivolous if the sufficiently well-pleaded facts are clearly baseless. That is, if they are fanciful, fantastic, or delusional. Wow. Fanciful, fantastic, or delusional. But what if they are fanciful, fantastic, and delusional? Which, claiming a spiritual medium told me that these are the facts. I think that qualifies as all three, as fanciful, fantastic, and delusional. And that was citing Gallup v. Cheney from the Second Circuit in 2011, which itself quoted Denton v. Hernandez from the Supreme Court in 1989. Related to this application of Rule 8 is the rule that a district court has the inherent power to dismiss an action that is so patently lacking in merit as to be frivolous, citing Guthrie v. U.S. Government from the 11th Circuit in 2015. Whether the court applies Rule 8 or exercises its inherent power, Guillard's claims should be dismissed because they are fanciful, fantastic, delusional, and patently lacking in merit. Guillard does not allege a single shred of direct or circumstantial evidence or an actual fact suggesting Professor Schofield had an affair with a student or ordered the murders. Guillard merely says her spiritual research intuitively led to the University of Idaho History Department. She then spiritually inquired into each person listed on the History Department's webpage, and her insight for Rebecca Schofield revealed that she was in a relationship with Kaylee Gonsalves that broke up, and that she initiated the murders, planned the murders, and hired help to carry the plan out. Spiritual research, intuition, and insight are not enough to plausibly allege anything, let alone something as serious as a teacher's inappropriate affair with a student, followed by the ordering of 4 murders. Even as a pro se litigant, Guillard should not be allowed to use this court as a platform to make frivolous allegations, to continue her shameless self-promotion at the expense of Professor Scofield's reputation and the peace of mind and her peace of mind and the victim's memories. Because Guillard's allegations are implausible and lack any basis in fact, her counterclaims should all be dismissed. Guillard's counterclaims also fail because they rely on group pleading that lacks the specificity needed to allege a conspiracy. Guillard alleges that collectively, attorney Olson, Watkins, and Carone and Professor Schofield conspired to deprive Ashley Guillard of her rights as an American citizen to free speech guaranteed by the First Amendment of the United States Constitution and of an impartial tribunal guaranteed by the 14th Amendment of the United States Constitution. How many times do you remember me reading that exact phrase from the counterclaims? Because it was in every single counterclaim, all 11 of them. Guillard appears to allege that Professor Schofield and her attorneys conspired by suing Guillard for defamation and then responding to press inquiries about the lawsuit. Guillard fails to allege which actions any individual took in the formation and execution of this alleged conspiracy. She instead offers mostly conclusory allegations that Professor Schofield and her attorneys conspired to harm her. Footnote 2. E.g., ECF 20, paragraphs 2, 4, 42 through 43, 47, 60, 62 through 63, 89, 96, 98, 107, 113, 109, 108, 167 through 169, and 205. That is what is known as group pleading or shotgun pleading, the concept of listing a group of people as defendants and generically claiming they violated Guillard's rights, citing Dana v. Tewalt, District of Idaho, 2022. Does that shotgun pleading, does that remind you of someone else who I maybe should have been covering tonight instead, but wanted to do this one instead? Oh, that's right. When Delete Laws says, these people are all agents of Kate and of all the other defendants and blah, blah, blah. And that's exactly that. I love this definition of it. Group pleading or shotgun pleading. That's exactly what Delete Laws has done in both of his lawsuits that involve Kate. I like that. That form of pleadings is deficient for any type of claim, but it is particularly deficient for a claim of conspiracy that requires specificity, which cites the previous case, the Dana v. Tewalt, but see also Taylor v. Babcock from the Ninth Circuit in 1992, which says vague and conclusory allegations of participation in civil rights violations are not sufficient to withstand a motion to dismiss. Guillard's counterclaims should thus all be dismissed. Next, Guillard's defamation claims, counterclaims 1 and 2, fail because 28 U.S.C. section 4101 does not apply, and filing a lawsuit cannot give rise to a defamation claim. Guillard alleges defamation under 28 U.S.C. section 4101. Section 4101 is the definition section of a statute on recognition of foreign defamation judgments. It plainly does not apply here. You remember me saying that? Even if Guillard had alleged a state law defamation claim, her claims fail legally. Professor Scofield's complaint and the statements made in the complaint are part of a judicial proceeding. They are privileged and do not give rise to a defamation claim. Citing Berrien versus Berberian. Seriously? Berrien versus Berberian? Wow. Berrien versus Berberian. I don't know why I'm so amused by that. Which is an Idaho state law case from 2020. State court case, which says Idaho has long recognized that defamatory statements made in the course of a judicial proceeding are absolutely privileged, even if made with malicious intent or knowledge of their falsity. And also, Dickinson Frozen Foods, Inc. versus J.R. Simplot Co., also Idaho, I think that's Idaho Supreme Court from 2019, as amended in April of 2019, where they say, we have also stated that the term judicial proceeding is not restricted to trials, but includes every proceeding of a judicial nature before a court or official clothed with judicial or quasi-judicial power. As to the media's coverage of the lawsuit, remember, I'm mentioned, Professor Schofield is not responsible for statements made by the press. Exactly. Professor Schofield is in no way responsible for what I have said. When I say Ashley Guillard is clearly delusional, I say that because I have watched her videos. I say that because I have read her legal filings. I have formed my own belief that her pleadings are delusional. That's on me. Of course, I think any reasonable person would come to the same conclusion, so. She likewise cannot be held liable for statements that Wendy Olson made in response to press inquiries that Ms. Olson received. Footnote 3. This motion is filed only on behalf of Professor Schofield. Her attorneys, Wendy Olson, Elijah Watkins, and Corey Carone, are not parties to this lawsuit, and thus Guillard's putative counterclaims against them are improper and inoperative. See Federal Rule of Civil Procedure, Rule 13. The court should thus dismiss counterclaims 1 and 2. Next up, Guillard's 42 U.S.C. Section 1985 2 claims fail for many reasons. Guillard next alleges claims under 42 U.S. Code Section 1985 sub 2, asserting that Professor Schofield has conspired with her attorneys to interfere with Guillard's rights to due process and freedom of speech by suing Guillard for defamation in what she believes is the wrong venue. Section 1985 sub 2 is a federal civil rights statute that prohibits conspiracies to obstruct justice by intimidating a jury party or witness. Guillard's claims fail for many reasons, each of which requires dismissal of these claims. First, Guillard's 42 U.S.C. Section 1985 sub 2 claims fail because she does not plausibly allege a race-based motive for Professor Scofield's lawsuit against Guillard, which is required for claims alleging interference in state court proceedings. Here, the prosecution of Mr. Kohberger. Do you guys remember me saying exactly that way back in like January or February when I covered the first answer? I said, hey, there's no race-based motive. Besides which, she's not a witness. She's not a juror. She's not a party to the Brian Kohberger trial, the criminal trial. She's a nothing to that trial. She's a sideshow circus. If I had a good singing voice, I'd sing Tool, the three-ring circus sideshow, flush it all away. And that cited 15 Amjur second edition, Civil Rights, section 176. Claims of conspiracies to obstruct justice in state courts require a showing that the conspiracy was motivated by a racial or otherwise class-based discriminatory animus. See also Jones v. Norton from the 10th Circuit in 2015, which recognized that an action under 42 U.S.C. section 1985 sub 2 requires a showing of some racial or perhaps otherwise class-based invidiously discriminatory animus behind the conspirator's action. Also, Limehouse v. Delaware from the Third Circuit in 2005. With respect to the Section 1985 sub 2 and 3 conspiracy claims, we find no evidence sufficient to raise an inference of a race-based motive for the defendant's alleged actions under Section 1985 sub 2 or 3, and thus plaintiff failed to state a claim upon which relief can be granted. Because Guillard has failed to allege that Professor Schofield had a race-based motive to sue Guillard to interfere with Mr. Kohberger's case, Guillard's claims fail. Oof. This room, when I have the door closed, the temperature just goes higher and higher and higher. Needed my jacket when I started, but not anymore. Second, Guillard cannot allege a conspiracy based on Professor Scofield's interactions with her attorney, nor has she alleged such a conspiracy with specificity. A claim under 42 U.S.C. section 1985 sub 2 arises if two or more persons conspire to obstruct justice. As long as an attorney's conduct falls within the scope of the representation of his client, such conduct is immune from an allegation of a Section 1985 conspiracy, citing Furries versus Shearer, 11th Circuit, 2003. Here, Guillard alleges a conspiracy because Professor Schofield, in conjunction with her attorneys, sued Guillard for defamation, and because Professor Schofield's attorney, Wendy Olson, responded to press inquiries about the lawsuit. Because filing a complaint and responding to press inquiries about the complaint fall within the scope of Professor Schofield's attorney's representation of her, Guillard has failed to allege a conspiracy that is actionable under 42 U.S.C. section 1985 sub 2. Further, as described previously, Guillard has failed to allege sufficient details of the conspiracy to meet the specificity requirements. Third, Guillard is not a party to Mr. Kohberger's case. Exactly. She's a three-ring circus sideshow. Mr. Kohberger's case is between him and the state of Idaho. She is also not a witness. For the purpose of the statute, the word witnesses means not only persons who have actually taken the witness stand in court or who are under subpoena, but also to persons whom a party to litigation intends to call as a witness. Citing Amger once again. Guillard does not allege that she has been or will be called as a witness at Mr. Kohberger's case. Because she is neither a party nor a witness to the case that Professor Schofield is allegedly interfering with by suing Guillard for defamation, Guillard has failed to state a claim. Fourth, Guillard has not alleged the right type of harm. 42 U.S. Code section 1985 sub 2 prohibits actions that impede the due course of justice in a state court proceeding or to injure the plaintiff's property for attempting to enforce the right of a person to the equal protection of the laws. Guillard alleges harms to her freedom of speech and due process rights. The former has nothing to do with the due course of justice. To the extent the latter does, the alleged interference is that, in Guillard's view, this action was brought in the wrong venue, or that the jury pool in this action will be biased against Guillard. Neither has any effect on Mr. Koberger's case. And Guillard has potential remedies. A motion to change venue, probing voir dire, the jury selection, a delay of trial, etc., which she has either opted not to pursue or could try to pursue in the future. Because she didn't submit a motion to transfer venue to Texas. In fact, she argued that the appropriate venue for her counterclaims is Idaho, and hey, there's only going to be one case, so you're stuck in Idaho. But the voir dire and a potential delay of trial, hey, those are future actions. Sitting on potential remedies does not give rise to a cause of action under 42 U.S.C. Section 1985, sub 2. Finally, to the extent that Guillard alleges property damage, she does not allege that Professor Schofield sued Guillard for defamation to interfere with Mr. Koberger's right to the equal protection of the laws under 42 U.S.C. Section 1985, sub 2. The court should thus dismiss counterclaims 3 and 8. Next, Guillard's 42 U.S.C. Section 1986 claims fail because she has not alleged actionable conduct under 42 U.S.C. Section 1985. Remember, I said this exact same thing. If 1985 isn't pled properly, 1986 is going to fail because it's basically the enforcement statute for 1985. Guillard next alleges claims under 42 U.S.C. Section 1986. Section 1986 creates a cause of action for neglecting or refusing to prevent an actionable conspiracy under 42 U.S.C. Section 1985. To bring a claim under 42 U.S.C. 1986, it is necessary to show that an actionable claim existed under 42 U.S.C. 1985, citing 15 Amger, 2nd edition, Civil Rights, Section 183. For the reasons provided, Guillard has failed to state a claim under 42 U.S.C. Section 1985. She thus has also failed to state a claim under 42 U.S.C. Section 1986. Hey, even the best make typos. That should read 1986, not 1985. The court should dismiss counterclaims 4 and 9. Next, Guillard's 42 U.S.C. Section 1983 claim fails because she has not alleged any state action. Although I think she's trying to allude that because Professor Schofield is a professor at a state university, that means it's state action, except that would be just as ridiculous as saying, hey, Professor Schofield's a public figure, either because she's a professor, which could possibly make her a limited public figure for the, like, if you were to defame her for the purposes of, you know, the history professor community. But you can't defame someone to a national audience that makes it go viral and then say, hey, look, there's all these videos talking about me defaming her. That makes her a public figure, so the actual malice standard applies. That's just as ridiculous as the Section 1983 claim. Guillard next alleges a claim under 42 U.S. Code Section 1983. Section 1983 is the civil rights statute that allows citizens to recover for deprivation of their rights under the color of state law. Section 1983 actions can be asserted only against state actors or in very particular circumstances against private actors acting under the color of law, citing Scott v. Thompson from the District of Idaho in 2020. Professor Schofield is a private citizen acting in a private capacity to sue Guillard for defamation. Guillard's Section 1983 claim thus fails. The court should dismiss Counterclaim 5. Guillard's malicious prosecution claims, Counterclaims 6 and 7, fail because Professor Scofield's defamation action against Guillard has not been terminated in Guillard's favor. Guillard next alleges claims for malicious prosecution. An action for malicious prosecution requires proof of the following requisites. 1, that there was a prosecution. 2, that it terminated in favor of plaintiff. 3, that the defendant was the prosecutor. 4, that the defendant was actuated by malice. By malice. It can't be a mistaken belief. So even if Professor Scofield's claims were dismissed, they're not going to be, but even if they were dismissed, she didn't bring the claims out of malice. She didn't bring the claims out of, and here it's going to be the actual malice standard, similar to the defamation actual malice standard for defamation pro se. So it's not going to be, she brought it because she was mad at her, because she doesn't like her, not that kind of malice. It's going to be the conscious disregard of the truth, basically. So it's not going to be that she had a conscious disregard of the truth here, and therefore she had malice bringing it. It'll be, well, she just didn't quite have enough to get across the finish line. So that prong is going to fail either way. Number 5, that there was a want of probable cause. And 6, that damages were sustained, citing Howard v. Felton from Idaho State Court in 1963. Professor Scofield's defamation claims against Guillard have not been terminated in Guillard's favor. Guillard's malicious prosecution claims thus fail. The court should dismiss claims 6 and 7. See, I like this. So there's 6 elements to the cause of action for malicious prosecution. We just went through all 6 of them. Professor Schofield says, hey, number 2, that the cause of action was terminated in favor of the defendant. Well, in this case, plaintiff, but plaintiff for the malicious prosecution cause of action. So defendant in the original malicious prosecution cause of, well, whatever the cause of action led to the malicious prosecution. It's all wibbly wobbly. But element 2 failed. Therefore, hey, she hasn't pled a sufficient cause of action. So if one of the 6 elements fails, the entire claim fails. We don't even have to discuss any of the rest. We don't have to discuss malice. We don't have to discuss a want of probable cause. We don't have to discuss damages. Number 2 failed, so the whole claim fails. Bye-bye. Next up, Guillard's intentional infliction of emotional distress claims, counterclaims 10 and 11, fail because filing a defamation action is not extreme or outrageous. And remember, I've said this many times. RICO is the legal equivalent of lupus, being a reference to the TV show House MD, where House says it's never lupus, except for that one rare occasion when it was actually lupus. And hey, he got thrown off because he discounted it as lupus because it's never lupus. Well, intentional infliction of emotional distress is RICO's cousin. Guillard's final claims are for intentional infliction of emotional distress. 4 elements are necessary to establish a claim of intentional infliction of emotional distress. 1, the conduct must be intentional or reckless. So it can't be negligent. It's got to be intentional or reckless. That's the higher level of intent, or if it were criminal, the mens rea. But 2, the conduct must be extreme and outrageous. That's a very tough burden to meet. 3, there must be a causal connection between the wrongful conduct and the emotional distress. And 4, the emotional distress must be severe, citing the estate of Becker versus Callahan from Idaho Supreme Court in 2004. Now, you'll notice that there's a hint. There's a hint in that case citation. The estate of Becker. That means they're suing on behalf of the estate of Becker. So I'm guessing the cause of the intentional infliction of emotional distress claimed in this case was the death of Becker. We're talking death or severe injury is generally what's going to be required to meet the threshold. It's not always the case. You know, I mean, maybe kidnapping someone's child might suffice. But it's going to be that high of a burden. But continuing on here, suing somebody for defamation is not extreme and outrageous. It is a quite common way to assert one's rights to defend their reputation, where the defendant has done no more than to insist upon his rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. Liability for intentional infliction of emotional distress does not lie, citing Edmondson v. Shearer Lumber Products, also from the Idaho Supreme Court in 2003. Guillard's intentional infliction of emotional distress claims thus fail. The court should dismiss counterclaims 10 and 11. Finally, the court should exercise its inherent power to award Professor Schofield her attorney's fees. Like I said, I glanced at this section mainly because I was interested if it listed the hourly rate for her attorneys. And once again, I want to say, I highly doubt that Professor Schofield or her attorneys watch my videos. But if there's any chance they do, please, Professor Schofield, start a GoFundMe for your attorney's fees. They'll be paid. Just do a GoFundMe. Your attorney's fees will be paid. You've got so many supporters. I mean, not a whole lot watch me, but between Emily D. Baker and the commentary channels, the think Atozi, Markey, iNabber, you're looking at millions of viewers. Your attorney's fees will be paid if you do a GoFundMe. Please do it. Guillard's conduct throughout this case shows a clear desire to delay the proceedings, to ignore reasonable requests from Professor Scofield's attorneys to cease and desist defaming Professor Scofield, and to increase the litigation costs for Professor Scofield. The court has the inherent power to correct such bad faith misconduct, citing Mark Industries versus Sea Captain's Choice, Inc. from the Ninth Circuit in 1995, which says the district court had discretion to discipline Bertram pursuant to its inherent powers for willful abuse of the judicial process or bad faith conduct. As the court is aware, Guillard found time to post numerous posts about this lawsuit online, yet could not find the time to file timely responsive pleadings. Then, when the court showed leniency to Guillard by giving her a second chance to participate in the litigation, she responded by filing 11 frivolous counters and making spurious accusations about Professor Schofield and her attorneys. As a result of Guillard's conduct, this litigation has been pending for almost 6 months, and discovery has not even begun. The judges put an end to that. See my last video. Moreover, Professor Schofield has incurred significant legal fees on the mere preliminary stages of litigation in a case where the defendant's only defense is that spiritual research led her to post sensationalist and defamatory content online. Professor Schofield's annual salary is under $90,000 per year, and at the current pace, she will need to choose between letting Guillard continue to shamelessly defame her online or put her family in financial jeopardy to vindicate her reputation. Or do a GoFundMe. Please do a GoFundMe. Please do a GoFundMe. Do a GoFundMe. In the interest of justice, Professor Schofield urges the court to exercise its inherent power to send a clear message to Guillard for the rest of this litigation and award Professor Schofield her attorney's fees spent combating these frivolous counterclaims and attempting to hold Guillard accountable for not complying with the court's deadlines. Conclusion. Professor Schofield requests that the court dismiss with prejudice all of Guillard's counterclaims and award Professor Schofield her attorney's fees. Dated June 6th, 2023, by Stoll Reeves, signed Wendy Olson and Elijah Watkins and Corey Carone, and served on June 6th, 2023 by ECF. So that's what we have for today. I expect, unless for some reason the magistrate is a believer in psychics and tarot cards and such nonsense, I absolutely expect, after the sufficient procedure has run its course, and oh boy, do I look forward to the opposition motion to this motion to dismiss. It's going to be a hot mess. But after the opposition motion, I fully expect that the counterclaims are going to be dismissed. They're that much nonsense. And it's possible that the professor gets her fees paid along with the dismissal, but I'm not going to hold my breath. So with that, thanks for joining me tonight. I will see you guys very soon for more of Delete Law's nonsense. And boy, is it nonsense. And please do all the YouTube-y things on your way out. Like, share, subscribe, bribe your friends into doing the same. And I will see you soon. Thanks for joining me. Bye-bye.